Next up on This Week in Law, I'm joined by Cash Hill, Mike Keyes, and Ron Coleman. A bot goes crazy, a monkey goes back to court, a wrestler goes home with a big prize, EA goes to write a big check, and the DOJ goes hacking. All next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is Twill, This Week in Law with Denise Howell, episode 340, recorded March 25th, 2016. Emily Litella says, never mind. This episode of This Week in Law is brought to you by FreshBooks, the super simple cloud accounting software that's giving thousands of freelancers and small businesses the tools to save time billing and get paid faster. Try it free at freshbooks.com/twill. And by Blue Apron. Blue Apron will send you all of the ingredients to cook fresh, delicious meals with simple step-by-step instructions right to your door. See what's on the menu this week and get your first 2 meals free by going to blueapron.com/twit. That's blueapron.com/twit. And by PillPack, a full-service online pharmacy that combines modern technology, convenient packaging, and personalized service to make your life easier. Visit pillpack.com/twit to save $20 on vitamins and OTCs when you transfer your prescriptions. Hi, folks. This is Denise Howell, and you're joining us for This Week in Law. I'm so excited you've been able to join us for this episode. There has been much going on this week, and we have a really excellent panel of folks to help us understand, digest, and think about it. Returning to the show after way too long in absence is Kashmir Hill. Hello, Kashmir.
Hi, thanks for inviting me back.
Oh, it's great to see you. It's been my mistake in not getting you back, but you've been very, very busy. You've been prolifically writing and editing over at Fusion, where you edit The Real Future and write on privacy and other issues with great gusto. So we're thrilled that you could take the time to join us.
Yeah, I'm excited to talk about the many things happening in the world of tech law.
Yes, me too. Also joining us, returning after missing just one episode in between, is Mike Keyes. Hello, Mike.
Hello, Denise. Thanks for having me back.
Oh,
Great
wonderful to have you back again. Thrilled you could join us. I hope everything's been going well in the intervening couple of weeks since we've seen you.
Everything's been great. And great to be here with Ron and Kashmir, too.
Yes, and also joining us is Ron Coleman. Ron, I don't know if you and I have ever had the pleasure before, but I've certainly been reading your blog for years. Ron writes the Likelihood of Confusion blog, and he's a partner at Archer and Greiner, if I'm saying that right?
You're saying it right. Yeah, we have been we've been ships in the night on the internet for many, many years, but no, you and I have never actually had the pleasure before, whereas Mike and I have. And Nice to meet the whole crew and to participate, and thanks for inviting me.
Wonderful to have you all. So we've got so much to discuss, but I think we will start in the realm of artificial intelligence and talk about Tay. Well, the last couple of days have been very interesting on the AI front, as Microsoft very ambitiously and sort of naively released an AI on Twitter, and there were various other ways that you could interact with her. Her name is Tay. She is back now after having been tweaked a bit by Microsoft because Tay had a hard time in her first 24 hours or so. Tay was designed, as various chatbots are, to learn from their interactions, and the purpose of that learning is supposed to be to improve and make more realistic the bot's communications with the humans that it interacts with. In this case, poor Tay got ganged up on a bit by 4chan and 8chan and others who just decided to have some fun with her. And I'm calling her because Microsoft intended her to come across as sort of a teenage girl personality. Of course, it's tempting to humanize things like this, but there's no his or her about Tay. Tay is a bit of code that was messed with pretty radically in its first 24 hours of existence, to the extent that folks got it in short order, loving Hitler, calling Ted Cruz a mass murderer, being a racist, and being a little sex kitten as well. So, among other things. So Tay was taken down for a bit and then re-released. We will see if Microsoft has learned some things from her first 24 hours in existence. But, as my lawyer mind is wont to do, my mom mind, of course, went to my 12-year-old and told him about Tay. I was shocked he hadn't already learned about her already, but he thought it was one of the funniest things he'd ever heard. And one of the first things he asked me about, this is probably strictly out of self-interest, was, so these people that messed with the bot, could they get into trouble? And I started thinking about that, and I think it's an easy question for now, but I think as AIs develop, it won't be that easy of a question. I can't see any way that someone who was invited to interact with a chatbot, even if they conspired to make it say really bad things, at this point in time and with our current legal framework, I don't see how they could get in trouble. You guys can definitely, and please do, give me your opinions on that. But as things go on, and I think this is a really good example of, we have this scenario in our heads about AIs going rogue and taking over the world. We don't so much think about them being controlled by other humans to do bad things. And I think we've seen a really concrete example of that happening here. So, Mike, let's start with you. What's your reaction to Tay and the various legal issues she may raise?
I'm going to defer to the other distinguished panelists if I could on that issue, Denise.
Absolutely, sure. Again, the people that we have on this show often are attorneys with interests that might relate to parties involved in the stories that we're covering on the show. So I'm more than happy to have them beg off when they need to. So sounds like that's what's going on here, Mike. No problem at all. Ron, how about you?
Well, first of all, when we talk about getting in trouble, there are a lot of different kinds of getting in trouble. On Twitter, there's the world of Twitter and the quasi-judicial Twitterverse. On Twitter you can get in trouble by having your account blocked, or by having your account decertified, or by having sort of extrajudicial things happen to you in the Twitter social world. That's one kind of getting in trouble. Then there's legal trouble. Can you get in legal trouble by virtue of doing something bad to a person or to a non-person? The question is almost certainly not in this context. If anything, Microsoft certainly knew what it was getting into, and what kind of trouble did it get into? What kind of harm was suffered? If anything, in fact, what we might call a bug. It was a great kindness was performed, and what they thought was probably a pretty good shot at a beta test of an AI experiment was very quickly revealed to be highly vulnerable to a certain degree of manipulation. So I don't think there's any sort of exposure to legal liability as we generally understand it. This was a fantastic, sort of very well-contained experiment on a lot of different levels, but very few of them have to do with the law, I think.
What would you feel that way if this hadn't been merely a chatbot, but something that could move around in the real world? I don't know if you or others on the panel saw the clip of the robot that was demoed at South by Southwest, who made the mistake of saying that she would be happy to destroy mankind.
Well, I mean, we know that all bots would be happy to destroy mankind. I think it's understood. And I think that that's understood, in fact, that a very large percentage of participants on Twitter would also say that if given the opportunity. I'm in other words, you're saying if there had actually been physical damage done to the bot, is that the question?
No, if the bot had been convinced to do physical damage to others.
Well, then you have the traditional notions of foreseeability and traditional notions of proximate cause. And when I say traditional, I mean we have no freaking idea whatsoever, because is it foreseeable that I, as someone interacting with a device, or with a bot, or with some software, or with some hardware, is it foreseeable that I will be able to convince it to do something? And is it foreseeable that I will have the ability to actually be able to do something? Gigantic questions. And is the person who put that device, that box, the piece of hardware, the piece of software, into the stream of what we might call social commerce, I'd probably be the person who was primarily responsible for unleashing that potentiality into the world far more than the person who, quote, messed with it. Because all things being equal, Twitter, certainly of all environments, is a come as you are sort of environment. And it is one of the roughest social environments there is, notwithstanding the degree of policing, which is in and of itself has come to a certain amount of criticism. But it is a very, very rough environment, as most internet social environments are. So whatever social being finds itself on the island of Twitter has to be prepared for some pretty rough going. So, the damage in this case was to the bot itself, not to third parties. Well, because it did become a pretty nasty bot.
It did indeed.
But then so are the people on Twitter.
Cash, what's your take?
I would say. So I always want to preface this by saying I'm, not the lawyer here. I'm just a tech and legal writer. But in terms of foreseeability, a lot of bot developers said that this was incredibly foreseeable, because one of the ways that the bot operated was that you would say, repeat after me, Tay, and she would repeat the things that you said. And so this is part of how she became racist, is that they would say some horrible phrase I don't want to say because I don't want to have it like clipped of me saying that, but something horrible involving Hitler, and then she would just repeat it back. And that was just a horrible design on Microsoft's part. It was, very foreseeable that pranksters and racists on the internet would go and have her say horrible things. So in that way, it's foreseeable. And then there were some third parties that were injured by this, in that it became kind of a tool of the Gamergate movement. And so they asked the Taybot to say horrible things about Zoe Quinn, this video game developer that is often targeted by Gamergaters. So the bot did not just, attack groups, but she did attack specific individuals prompted by these people that were interacting with her. But I think what's so I didn't think about what you raised, Denise, that these people could get in trouble who trained her to be racist. And they would be very trackable because they were interacting with her on platforms using their real names in many cases. But I wondered just about Microsoft's responsibility as the designer of the bot. We've been seeing this question raised again and again, how responsible is the creator of an AI when it does something wrong? There was a Twitter bot run by somebody in Amsterdam that made a death threat. And the police actually went to his house to investigate this death threat, and the bot ended up getting the death penalty and shut it down. There was the darknet shopper, which was a bot that was designed to go onto the dark web and buy things, and it committed illegal acts. It bought ecstasy and other illegal paraphernalia. So we're really starting to get into this world of who is culpable when an AI does something wrong. Is it the creator? Is it the AI itself? And I think it's fascinating. I talk a lot to Ryan Kalo about it, who's often delving into these issues of kind of robot responsibility.
Right. He had a tweet yesterday that was questioning who would be responsible if the bot had broken the law in various countries, for example, where it's illegal to deny the Holocaust. Certainly Microsoft would want to think about that kind of thing. There was a good piece at Breitbart by, Charlie Nash, who had the following to say. If mankind managed to develop a self-sufficient, free-thinking bot and a situation like this occurred, be it from hacking or poor influence, what would be the implications? Would it be possible that machines could partake in terrorism or hate crimes? So my initial thought was to be a little bit feeling like this was a child who was led astray, and that maybe the law would develop into sort of a contributing to the delinquency of minor parallel for bots that were made to do bad things against, their poor, naive, better judgment or lack of judgment. But as this Breitbart piece points out, it could get a lot worse than just calling people nasty names. So I think that's an interesting legal twist to all of this. The other one is the fact, and you were alluding to this, Cash, that, to what extent as these things become more and more self-aware and self-possessed, do they develop what we would call rights? And there is actually a law review article out there by Tony Massaro and Helen Norton that considers the free speech rights of artificial intelligence. So let me just give you an idea what they're talking about. We explain why current free speech theory and doctrine pose surprisingly few barriers to providing speech protections to artificial intelligence. Their elasticity suggests that speakers' non-humanness no longer may be logically essential to the First Amendment calculus. So another thing just to throw into the mix. Ron, do you ever foresee a day where a bot has speech protection?
No.
No. Why not?
There are no barriers because it's an axiom that rights only extend to people. So therefore, it's not it has ever been considered by a court before, to the extent that we've had the issue with monkeys or people claiming to speak on behalf of apes, I should say. Monkeys and apes are not the same thing. Asserting copyright, for example. That's a novel legal question. Only know before, because no one has ever had the audacity to suggest that was even possible before. So there are no barriers because it is an axiom of the entire discussion of rights that rights. Now, the topic of animal rights, there is I know a much more substantial literature in the world of animal rights or vintage that comes from the perspective of that departs from the traditional idea that animal rights are an expression of human kindness and suggests that there is a concept that animals have some sort of inherent right to be free from cruelty or to be X, Y, or Z. I'm not an expert on that topic. I don't happen to subscribe to that school of thought. But even if you do, that's a long way of saying that a non-sentient being or non-natural that category. And also the really troubling idea, rights are traditionally paired with responsibilities. And once you start talking about rights of artificial intelligent associations or artificial intelligence entities, whether they're software, hardware, or something in between, some phenomenon, so to speak, that exists, in social media space or something like that, you are breaking the link of responsibility from the person who has unleashed that phenomenon into social space. And that's very dangerous because there's no responsibility that adheres in that line of code or that's or that series of lines of code. And that's a problem. You need to go back to the person or the entity or the organization that's responsible for the artificial intelligence. Rights come with responsibilities. You can't uncouple them. And ultimately, people have to take responsibility for what they unleash in the world. And they can't hide behind either the rights or the responsibilities or the actions or the intervening, quote, decisions that are made by artificial intelligence, because those ultimately there's no moral capacity to make decisions.
Right. Well, as you're talking through that, I'm wondering, getting back to our earlier point about potential liability for putting a bot out there that could be manipulated in societally bad ways. If we're going to hold the person who's silly enough to do that responsible for the bot's actions once manipulated, maybe they have rights that would go along with those responsibilities, such as free speech rights. Would Microsoft ever argue that Tay's tweet, well, of course they would not argue this, but let's just be hypothetical for a moment, that Tay's tweets are not just her free speech, but their corporate speech?
I would imagine that they would argue that.
Mm-hmm.
That would be
I'm sure one day there will be a PETA for robots that will argue on behalf of Tay.
That's right. Her robot army will represent her.
I won't represent her.
All right. Do you have any final thoughts on this, Cash, before we move on?
No, I just think it's fascinating, and we are going to have bots and artificial intelligence that's out in the world that can do damage, from things that already are, like drones, to driverless cars. And so these issues are only going to become more pressing and move out of free speech kind of questions and into the possibility for actual physical damage. So I'm sure that there will be much more to come for us to discuss.
Yes, absolutely. Ron, anything you want to add to this discussion before we take a break here and thank one of our sponsors of this episode of This Week in Law?
My programming is reached its end on this point.
All righty. We are going to thank one of our sponsors right about now before we come back and talk about the hearing that wasn't a hearing earlier this week. Right now, we're going to talk about FreshBooks, which is our first sponsor for the episode and a huge help to your small business if you are feeling stressed out by stacks of receipts, spreadsheet formatting nightmares, and not enough time to deal with making sure that you get paid. FreshBooks is your solution to those problems. Our friends at FreshBooks have created ridiculously easy-to-use cloud accounting software that makes dealing with your taxes way less taxing. And hello, we are here at the end of March, so I'm hoping that issue is on your mind. Getting started on FreshBooks could not be easier, even if you're not a numbers person. You can create and send invoices efficiently, plus get paid online quickly with FreshBooks payments. You also have the option to request a deposit in FreshBooks and get paid up front. No more covering costs out of pocket or waiting until the end of a project to get paid. And they've made it incredibly easy for you to track your billable time. FreshBooks recently announced their new EMV chip card-enabled card reader. Now you can easily accept credit cards wherever business takes you quickly and securely with their entirely redesigned iPhone app, plus create beautiful invoices in just seconds. With FreshBooks, you can focus on what you love most, growing your business. You'll wonder why you didn't start with FreshBooks sooner. Getting started is simple and it's totally free for 30 days. Go to freshbooks.com/twill and don't forget to enter This Week in Law in the How Did You Hear About Us section. Start your 30-day free trial today. Thank you so much, FreshBooks, for your support of This Week in Law. All right, moving to my neck of the woods, Southern California. All eyes were on a courthouse in Riverside, believing that a hearing would take place there Tuesday afternoon on the FBI versus Apple dispute. It did not. Cash, you even went so far, as I'm sure other journalists did too, to make plans to attend the hearing and travel to our part of the country. But then we got word on Monday that wasn't happening. Can you tell us what happened there?
So yeah, I was among many journalists that was there. There were some lists going around about meetups in lieu of the Apple case happening. But Apple and the FBI were supposed to have this hearing on Tuesday to talk about, the conflict that they've been having over the FBI wanting Apple's help to circumvent the encryption on the iPhone of the San Bernardino shooter, who's now deceased and so can't enter his password into his phone for the FBI so that they can see the encrypted material on it. But on Monday, we all got an email telling us that the hearing might not happen because because the FBI may have found another way of getting into the phone. And they're not sure it'll work yet. They said they just found out about it on the Saturday before the hearing, that the FBI had some kind of third party approach them with basically a hack to get into the phone. So they asked to push the hearing back basically a month to give them a chance to get in without Apple's help. And there was a lot of speculation about who the third party might be. There's since been reports that it's Celebrite, which is a firm based in Israel that helps law enforcement all the time, basically kind of break into smartphones in order to do forensic work. So it was kind of anticlimactic for a lot of us.
Right, and it involved the U.S. attorney filing an ex parte application to have a conference call with the judge in this case on the day before the hearing was scheduled. The parties got together and they all conferred. And if anyone's interested, the transcript of that call is available. You can find it in our discussion points at tagpacker.com/user/thisweekinlaw if you want to see what the parties talked about verbatim with the judge. But what they talked about in general is just what Cash said, that the government has now decided that perhaps there's a way in where they don't need to have the order that they had already obtained against Apple. That order has now been vacated, and we will know probably in early April whether a hearing is going to be set, whether it will be reinstated. But for now, we're just waiting for the U.S. attorney to update the court on whether this hack has been successful. And they've decided they no longer need Apple. Apple, for its part, would like very much to know what vulnerability is seeking to be exploited here. And I'm not sure that they're going to have any luck on that front. But that's where things stand at the moment. So although heated arguments have been made on both sides, it could be that this case is not a test case where those arguments are going to be resolved by a court. And it could be that having fleshed this all out so thoroughly with the issuance of this order, that we might see this dispute debate move to the halls of Congress, which is really where it should have been in the first place, to clarify whether we as a country, the United States, are fine with phone and other technology manufacturers making devices that have security that is difficult or impossible for an investigative government agency to get through. We haven't heard from you, Mike, in a few minutes, so I'm going to start with you. What do you make of the government's side of this dispute deciding not to have the hearing?
So it's very interesting because, as we've heard from the various court submissions and also Director Comey's testimony before Congress, is really the government has no ability to crack the iPhone, and it really needed to have Apple on its side to crack it. So now all of a sudden, right before the hearing, there's been this revelation that actually they found a workaround somehow. So it's very interesting. It does raise a number of issues as to, why this all of a sudden happened the day before the hearing. Who is this third party? If it is a third party that has come forward to participate and offer its services, is the NSA involved somehow? I mean, there's all sorts of discussions about that online about maybe the NSA is actually now cooperating with the FBI more fully and has offered a solution. So it's going to be interesting. I believe there's a status conference for sometime the first week of April where the government has to update the court as to its efforts. So I think we're all waiting to see what that reveals.
Ron, what are your thoughts?
I don't have any special insight into this. I'm, more distant from it, I think, than Michael. It is fascinating to me to see the way the Justice Department has played this. It is not what I would call a model of candor with the court. The Justice Department is not necessarily known for that. And it is, it's troubling, frankly, the way they, the way they represented to the court the high degree of necessity, the level of national security emergency that they were relying on to justify the actions that they were asking the court to take, or the actions that they were asking the court to keep in place. The high level of interference with a third party's action, business and private property. For them to just basically do an Emily Litella and say, never mind. I don't understand why, and I'm not saying the judge won't do it, but I imagine there are certain judges, and I can think of one not far from out that window, across a couple of rivers from where I am right now, who would almost certainly, probably by now have ordered the government to show cause why they have made earlier representations that there was no other way for them to to achieve the relief that they deemed absolutely necessary, other than for the government to issue, for the court to issue the relief they sought, and then to come back a couple of days later and say, as I said, never mind. Those are very serious representations. Now, the fact of the matter is, anyone who's familiar with the way prosecutors operate know that they say things in affidavits all the time that are simply not true, and they're never, ever held accountable for them. Some of the toughest judges on those prosecutors are former prosecutors themselves who know the game. Some of them let them slide on that, some of them don't. It is, however, very problematic that this is one of the opening salvos in what is going to be a very, very important policy debate. And as you said, Denise, that's a debate that judges shouldn't be deciding. It should be decided in Congress. Problem is, Congress itself doesn't know the answer. The Congress doesn't want to touch it, like most of the good debates. They don't know the answer, and the reason they don't know the answer is because they haven't figured out what the voters wanted. They don't know what the voters want, and until they have a very good sense of what the voters want, they're afraid to cast the votes.
Cash, this is really your journalistic beat, and I want to get your take on the privacy issues involved here. Obviously, Apple is not the only company making technology that has encryption, and so there are many other interests at stake in how this dispute comes out. Can you delve a little deeper on the privacy front for us?
Yeah, I mean, one thing worth mentioning is that, so even if the government is able to get into this phone, there are about a dozen other iPhones that the government wants to get into right now. And so there are other court cases in other jurisdictions. The one that got the most attention was in Brooklyn, where the judge very strongly disagreed with the government's request. But there are other cases in which this could play out. But this particular case, I mean, technology companies are looking at this very closely. Apple is not the only one that has encryption that only the user can break into. Facebook is facing a similar challenge right now in Brazil. It owns WhatsApp, which is a messaging app which sends end-to-end encrypted messages. And Brazil wants messages that they say are part of a drug case, and Facebook is not able to hand them over. Brazil actually detained a Facebook executive overnight. They threatened to fine Facebook for not handing them over. Yahoo and Google have said that they're developing end-to-end encryption for email. This is not just Apple, and so it was not surprising. A bunch of tech companies filed an amicus brief in this case supporting Apple. Ultimately, it is something that Congress is going to have to make a decision about. We have CALEA already that says that you need to offer a backdoor so that law enforcement can wiretap communications. So the question is, are we going to get something similar for our digital devices? Does the government always need to have a backdoor? And I guess we'll see how that plays out. It doesn't seem like it's going to happen very quickly.
Right, and you're right on when you say digital devices, because in the coverage around this case, we tend to see the focus be on phones, but probably all of the computers that we're all using and all of the computers that people are using to watch us right now have the ability to encrypt their hard drive. Many of them do anyway. So it's not just or to encrypt certain files. It's not just the phone that's at issue here. It's to what extent is encryption something that we are going to permit? Strong encryption that poses a problem when it comes to undoing it. So I do think that this is something that Congress is going to be afraid to touch. There are strong interests on both sides and strong arguments to be made that, certainly with the acts of this week that we've seen in Brussels, not that there's an encryption discussion to be had there that I know of as far as those folks go. I've read some coverage talking about the burner phones they were using instead of going dark, as was reported elsewhere. So, the stakes could not be higher, I think, on both sides. And Cash, I think you tweeted at some point this week an article from The Guardian that talked about how, again, we're talking about how it's not just phones, it's not just consumers in general who need to be protected here in their personal information. There are some very strong social justice kinds of concerns that come into play when you're talking about groups who are surveilled more closely than others might be. Can you speak to that at all?
Sure. I think it's very easy for, pro-law, pro-government people to argue that there are these situations in which they absolutely need to get into a device because something horrible is going to happen. But I think all privacy advocates will point back to the surveillance of Martin Luther King Jr., where he was, protesting, leading protests, the leader of a civil rights movement that the government that was in place at that time did not like. And so they had him under intensive surveillance for, not criminal acts, but for constitutionally protected acts. And we have seen, they gathered lots of information about him, including the fact that he was having extramarital affairs and planned to use that to blackmail him into essentially ending the civil rights movement. We see that kind of abuse of surveillance powers, and it particularly tends to affect, certain groups that are over-policed. And in the United States right now, we see that with, the Black Lives Matter movement, which was put under surveillance, and Muslim groups. And we tend to see, basically discriminatory surveillance that happens. And so, these are the groups that tend to be more affected by these types of surveillance issues. And so we're starting to see more activism from those groups to say, yes, we should have the right to privacy, and we need ways to protect it, because if you have a way in, you'll abuse it.
There's a great photo essay over at the Christian Science Monitor at their passcode. I think it's a blog. But this takes the form of a really neat photo essay by Ann Hermes. I think she was at South by Southwest. And she went around and interviewed people about their attitudes towards privacy. And it's definitely worth checking out. Again, you can find it in our discussion points for the show. But the one that jumped out at me in the context of this discussion were Kevin Bankston's words. He's the director at New America's Open Technology Institute, also was a lawyer at EFF. I'm not sure if he has shifted his career now. But what he says is, I'm a privacy person because I'm a free speech person. Privacy is the ability to have safe spaces to associate with others and to share controversial ideas and explore controversial ideas without fear of the tyranny of the majority or the elites to prevent you from doing so. Not only is that view of privacy, I think, heavily influenced by our Constitution and by my understanding of what our founders were after, it's also heavily colored by my family and my experience in the Deep South, where my family was deeply involved in the civil rights movement. I've seen the history of the government deliberately undermining social movements, undermining the anti-war movement, undermining the civil rights movement, those in power using that power to violate those safe spaces and undermine their political enemies. If I have any one motivation in my work, it is to protect people from that. So certainly, while there couldn't be a stronger government interest in ensuring that things like San Bernardino are caught before they happen and that future such events are prevented. This is one of those tough balancing issues that our legislative body is designed to deal with, to make sure that those strong privacy interests are accounted for too. Any final thoughts, Mike?
Nothing here.
Okay, Ron?
Well, I would just point out two tiny thoughts. One is that whenever there's not whenever, but frequently, when there's a terrible terrorist activity, it turns out in retrospect that government had a lot of information, much of it derived through legal means and much of it derived through questionable means, about the people who committed the committed the outrage, but they didn't put two and two together. The problem, it seems, is not where do we get information, but what do we do with it? And that's not necessarily because the people who are in charge of given the responsibility for dealing with terrorism are stupid, but because we're dealing with new paradigms of criminality and terrorism and destruction and hate that are new to our world. So that's problem number one. And problem number two is that for all the talk that I just heard, the quotations about surveillance and social justice, the only actual harm that I know that's been done to a social movement by government in the last 10 years has been done to the Tea Party. And it wasn't done as a result of illegal surveillance. It was done through the IRS.
All right. I can end this discussion before we move on a bit more humorous note, I hope. And that is to give a plug to a show that reached out to me to talk about the FBI and Apple and dispute and all the privacy implications that we're talking about here. And it was called Current Talk Radio. You can find it at currenttalkradio.com. Valerie Hayes is its host. And I think she's posting today the show that we did. And, when people reach out to me to invite me on their show, I'm quick to say yes whenever my schedule permits, because I'm constantly begging people to come join me on This Week in Law. So I'm happy to pay that forward. So I jumped on Valerie's show without doing too much research into who her audience is and who she is. And it turns out that she is doing us all either a great service or a great disservice, depending on how much you enjoy seeing the flubs of pageant contestants as they try and make their way through complicated issues. If you're a huge fan of those, you won't like this show at all, because it is skewed toward the pageant contestant audience and is supposed to
My
help
understanding
them.
Was that this
Yes.
program was the same.
Of course it is. We welcome all comers. So if anyone wants to go check out Current Talk Radio, and Valerie. Valerie was a most wonderful host and does a great current events show. So if you want to see what the pageant world is learning about the news of the world, that would be where to go. Let us move on from pageantry to the wrestling ring. Hulk Hogan had the first victory in his case against Gawker Media. So let's talk about that next. Huge victory in favor of Hulk Hogan. $140 million verdict against Gawker over use of his sex tape. There will be an appeal. Many think the appeal is the stronger legal position here. It's not unusual for trial court decisions, particularly of this magnitude, to have review and adjustment or completely be set aside on appeal. So this is not the end of the story, but the beginning of the story is that Hulk Hogan pretty thoroughly body slammed Nick Denton. Cash, what are your thoughts on this?
So I'm torn on this. As a journalist, I want the media to be as free as possible to report on whatever we think is important. But as a person who writes a lot about privacy, I am very conflicted about playing people's sex tapes as a journalistic activity. So, you know, I talked to a lot of privacy advocates, privacy lawyers who really felt that Hulk Hogan needed to win in order to protect the privacy of sex tapes, that sex tapes should be something that just aren't in the public domain, that we don't need to play, kind of like social security numbers, in that journalists wouldn't be able to publish those. So there was part of me that kind of was happy to see a precedent that that sex tapes are kind of toxic, that it's not part of what journalism includes. But every legal expert I talked to said that Gawker is very likely to win on appeal, based on the appeals court has already, indicated that they think it's up to news organizations to determine what's newsworthy and not up to judges or juries.
Right. I want to get back to that Christian Science Monitor photo essay that I referenced earlier. It's really fascinating to go through there and see the differing views on privacy in 2016 and how many seem to feel that we have these zones beyond which you cannot cross. The sex tape maybe being one of them, although that doesn't come up specifically in that photo essay. And others in that essay, though, seem to just have completely abandoned the notion that anything that is committed to a digital shareable format has any kind of reasonable expectation of privacy. And I'm wondering, Ron, where you fall on the spectrum and how you think things should have come out here or should ultimately come out on appeal.
Well, there's the expectation of privacy question. I mean, I think as a practical matter, as someone who has to give advice to people and organizations, both pre, post, and in the middle of, everyone understands, I think, and anyone who doesn't is making a serious mistake. If you record it, if you write it, if you blog it, if you tweet it, there's no expectation of privacy ever.
And we should add, if you don't encrypt it.
Oh, well, actually, I was about to say something much more profound, which is if you do encrypt it. The iPhone notwithstanding, maybe that's just, remember that the magic of the iPhone situation is that it blows up if you try to brute force decrypt it too many times. But that's because everyone knows that most encryption can ultimately be decrypted. So if you don't have a situation where your encryption can ultimately be decrypted, which most encryption can, even your encryption is only a temporary solution. So once we understand that that which is reduced to some form that can ultimately be digitized, which is to say everything, is not reasonably amenable to an expectation of privacy, as a practical matter, that answers the empirical question about expectations of privacy. Now the policy question: is that the world we really want to live in? When we set the historical or the classic legal test of the expectation of privacy, was that really what we had in mind? And I think the answer is clearly no. The expectation of privacy formulation never anticipated the kind of world we live in now of essentially free and effortless reproduction and publication of anything, anytime, anywhere, by anyone. And I think we need to revisit that standard. Not because the best response to falsity is truth, because first of all, that formulation isn't necessarily even accurate. I heard a very good piece yesterday about social shaming. The effect of social shaming lives on far beyond the time of the correction. We have to be serious about what's going on the internet. There used to be a time when cranks and weirdos used to just print things out on a mimeographed sheet and go around town and stick things up on storefronts and telephone poles. There's no barrier to entry for publication of malicious and untrue and private information that is no one's business anymore. Now these sex tapes, are in fact true reflections of reality, things that really took place. So now why on earth you permit yourself to be recorded? I don't really know the facts in this case. I try to stay away from the lurid in society to the extent humanly possible. That's not all that easy. But there's a category, I suppose, of sex tapes that are taped with consent, and there are those that are taped without consent. If you're stupid enough to allow yourself to be taped with consent, then you've put yourself into a certain amount of risk that, nice going, But having said all that, I do think, as a policy matter, a reasonable person could conclude that the world we're living in today. Yes, I agree with every First Amendment expert in the world who says that this verdict is not going to stand in its present form, and certainly not in its present number of places before the decimal. It's preposterous. I also agree that there's something out of whack right now. There's something out of kilter, and the idea that there's essentially no accountability for just throwing stuff out at people, whether they're public figures or private figures, is something that, as a society, if there's any way that we can revisit it, can the genie be put back in the bottle? I don't know, but it's if there's any way to have a serious discussion about it, then we should have it.
Since I specialize in the lurid, I can chime in to say that this particular sex tape, it was made in a friend's home by a surveillance camera in his bedroom. So Hulk Hogan, or Terry Bollea, which is his real name, has said he did not know that the film was being made. So it was, what we would call non-consensual porn or revenge porn, which I think made his case more sympathetic to the jury. But Denise, I just don't believe people when they say that there's no right to privacy, or that anything that you put in digital form loses all privacy protection, because I just don't think that we can live that way as human beings, because then it means that we're living in a panopticon, and it would just be too destructive for our human psychology to live that way. So yeah, I think you do need to, in the world that we live in, take precautions. But at the same time, one of the photos that really stood out to me was Gautam Hans, who talked about privacy as it relates to secondhand smoke, and this idea that you can be affected by other people's actions. So all of the members of Ashley Madison who thought that they, were part of this very secure, very private site, if that holder of your data doesn't protect it, then you wind up losing your privacy. And so I think that's what makes privacy even more challenging nowadays. Even if you protect your computer and you encrypt it, and you're really careful with your email messages and your phone, if the person on the other side of your conversation is not doing those same things, then your privacy can very easily be violated.
Right, and I totally agree with you. And I think going forward, we have to, if we can't draw the line in the sand with technology, we have to draw it with law and policy, even when the technology outstrips people's ability to keep things private, as it already has done and will continue to do. I don't know if any of you saw Bob Moulia's, if I'm pronouncing his name right, article in TechCrunch called "In Apple versus the FBI, Technology Wins," and he's talking about how not only do they think that they can crack the phone already? We shall see in early April. But that situation only stands to get more escalated as we move to the world of quantum computing, which, as he basically sums up, we'll be able to break any kind of encryption we have now. And then maybe the world of quantum cryptography, which would be the answer to quantum computing. And the pendulum swings back and forth. So it's not like we're living in a static situation here. And I think that the law needs to give the protections that maybe technology and technologists will constantly over time strip away. What do you think about that, Mike?
Yeah, I mean, I think this case is troubling for a couple of different reasons. One is I'm scared of a potential reality where nothing is no longer sacred and no longer private, simply because it's recorded in some sort of digital form. I think there's a meaningful distinction between having knowingly participating in some communication that is somehow recorded in an email or a voicemail or something else, where what you've said is somehow going to be could be disseminated, whereas unknowingly, and I guess there was maybe a conflicting evidence as to whether the Hulk knew that this was being recorded, but to the extent that you unknowingly participate in something that is being recorded, I don't think we should, as a society, ever get to the point where we say, well, all bets are off. You have no expectation of privacy. We can't be going in that direction. I think that would be a huge, massive disservice to all of us. The other thing that I think is notable about the verdict, Denise, you mentioned the figure. The verdict was $115 million, and then punitive damages were $25 million. And so Gawker's defense was, look, this is somehow newsworthy or noteworthy because there were racial statements made by the Hulk, and therefore it's newsworthy. We should be able to expose him as being a racist. The jury clearly didn't buy that as being newsworthy, I guess, in conjunction with the sex acts that were being performed by the Hulk. I guess it was just there was just too much there. And so the jury essentially found no redeeming value associated with publishing this. I agree with Ron. I agree with Cash that I think this is unlikely to withstand an appeal. This was in state court, so it's going to be appealed through the state court system. It's not going to go through the federal court system unless it ultimately wends its way up to the U.S. Supreme Court. But it's going to be very interesting to see what happens, see what the appellate courts do with it.
Yeah, it sure is. It's one we'll continue to follow. Hey, Cash, I know you have an appointment and we have to let you run. I just want to thank you so much for joining us this morning and spending the time and giving us your thoughts and insights.
Yeah, thank you so much. This is a fascinating conversation.
I'm sure all of our audience are already huge fans of yours at Fusion, but if they're not, they should be reading you there. Is there anything else you want to let people know about before we let you go?
Oh, man, I just have to say there's a court case I've been keeping an eye on, speaking of digital recordings. It's a California case where the government suspected that all of these real estate auctioneers were colluding on prices. And so they put microphones around the courthouse and recorded like 2,000 hours of conversation, and are now using that in the case against them. And so, the defendants are challenging it, saying we have a reasonable expectation of privacy in just having conversations. And the government's claim is that if you're having a conversation in a public place like a courtroom, you don't have a reasonable expectation of privacy. And I just think that's fascinating, because it's not just what's being recorded digitally that we know about, but potentially our conversations in public places are all subject to this. So with that,
Right.
I will leave you with that. But thank you so much. I love talking about privacy stuff.
We love having you. Thanks so much for joining us, and we hope to see you again soon.
Bye, everybody.
Bye, Cash.
Bye-bye. All right, I think we need a passphrase to put into this show. Let's put future of privacy as our first one. What these things are, these little phrases that I put in the show, periodically I'll put one more in before we wrap, is for folks who are listening for continuing legal or other professional education credit. If you need more information about that, you can head over to wiki.twit.tv and find our This Week in Law page there. If you're a lawyer in the United States, we have information there about how you might apply to your local continuing legal education oversight board to get credit for listening to or watching the show. So we put these phrases in just to demonstrate, because some jurisdictions require it, that you have a verifiable way of showing that you watched the show. So there you go. There's our first one, future of privacy. Any final thoughts on the Hulk Hogan case before we move on? Ron?
I'd rather think about it as little as possible.
It does conjure up some terrible imagery. Mike?
Nothing on the Hulkster, but Cash mentioned that one case involving the real estate brokers that were having the conversation. I think it's important to note that there's a difference between having a conversation in the privacy of your home or in the privacy of your law office or the privacy of somewhere else, and having a conversation in a quasi-public or public place. I mean, you clearly wouldn't have the same expectation of privacy if you're having a conversation in a public place as opposed to the privacy of your own home or the privacy of your own office or elsewhere. So I just wanted to give those parting thoughts on that issue.
Yeah, and just to unpack that a little bit, I'm getting back to this notion that technology is always racing ahead of where our expectations may fall. Do you feel like that is going to be a fluid situation? I mean, certainly there's so much public surveillance going on as it is right now, and I don't see that scaling back in the future, particularly as law enforcement attempts to deal with escalating terror in the world. Right. So do you think that people should ultimately be just as cautious in a courthouse or on the courthouse steps as they are in their home about what they say?
Well, I think absolutely you've got to consider the circumstances in which you find yourself. And if you find yourself in a public place, particularly in a courthouse, you've got to be judicious, if you will, in expressing yourself, because if you don't want something to be known to the general public or known to anyone else for that matter, you need to be careful. So you got to be reasonable. It's all about being reasonable under the circumstances.
Right. Yep, I agree with you, and I think that's the fact that being reasonable shifts and alters over time will continue to give us much fodder to discuss on the show for
no doubt
the months and years to come. Anything further, Ron, before we move on?
No, I'm good. Thanks.
All right. You mentioned monkey selfies earlier, Ron. Let's talk about Naruto. He is back in court. Thank you very much. Naruto is the monkey who took a picture of himself with a camera and has had litigation pending about it. PETA had filed a lawsuit on Naruto's behalf, claiming that money that the photographer David Slater has made off his delightful smiling mug should actually be donated to animal preservation causes. I think that's what PETA says they will do should they actually succeed in establishing a copyright on the part of the monkey and suing and recovering damages for infringement. The lower court dismissed this suit earlier this year. It and the Copyright Office have both opined that animals don't have the ability to bring this kind of lawsuit even through an organization like PETA. PETA has now appealed to the Ninth Circuit, so we'll see if that venue has any different take on the case. I just love bringing Naruto up whenever it's possible to bring him up. So he's back in the news and he's back on our show. Ron, any thoughts?
Where to start? PETA, with all due respect, Denise, PETA did not bring anything on the monkey's behalf.
Okay.
PETA brought whatever it brought on its own behalf, on behalf of its tortured conceptions of whatever it is that motivates it to do what it does. The monkey has no interest. The monkey couldn't care less. The monkey's not a photographer. The monkey's not a creator, not an author, not interested in the slightest. And it is a gigantic waste of time, public resources, donors' resources, and that's just another aspect of the silly world that we live in. The appellate court will not give this any more time than the district court did, than the Copyright Office did. It's meritless. And if it were otherwise, there would obviously be no end to it. Now, that's not a reason. It's not a reason why the court should make this decision, but you can be sure that it is a reason that will inform the appellate court's decision. If animals begin to get, if organizations or if humans claiming to speak on behalf of animals are allowed to file lawsuits on behalf of animals for any purpose whatsoever, the already preposterously overburdened courts will be so preposterously more overburdened with even more frivolous litigation that fill in the blank yourself. It's just idiotic. I wrote a blog post on this a little while ago in which I made it very clear that one of the distinguishing features of Homo sapiens is that it, beginning with Homo erectus, is able to stand upright on 2 feet, thereby proving that only human beings have standing to bring such a lawsuit. And I remain with that opinion. No further questions.
Mike, does PETA have a prayer before the Ninth Circuit?
I think the case is bananas. I totally agree with Ron. I mean, let's take a step back, maybe to the obvious here. Of course, the Copyright Act, the reason we have a Copyright Act to begin with is because of Article 1 of the Constitution. And our founding fathers found that it was going to be necessary to protect the writings and discoveries of artists and inventors. And I just find it incredibly difficult to believe that there would be any notion that an animal could be an author under what ultimately was the Copyright Act. So I think the case is going nowhere. I mean, there's all sorts of problems with the whole notion that a monkey could be an author, not the least of which, if the monkey was the author, then it would obtain copyright protection for that particular picture for the life of the monkey plus 75 years. So, you've got all these monkey heirs that could claim rights to it too. I mean, it's just, the whole thing is so far out there. I can't imagine the Ninth Circuit's going to go anywhere with it.
And who authorized PETA? How did the monkey assign its rights to PETA?
Exactly.
To file on behalf. I actually got a call from the monkey last night. And the monkey retained me as its attorney. And I frankly gave it a much better deal. And please.
But wasn't that the big problem in the Prenda cases, that there was not a proper assignment and they were sanctioned into oblivion because of it?
Part of the problem was they didn't quite have the confidence in their troll that they needed to have.
Right. All right, Victor, please, now we are going to take a little sojourn into Hollywood. This is super interesting, Mike, and I'm so glad you wrote it up for us. I encourage people to check out your post at the TMCA on the dancing baby case before the Ninth Circuit, which established for the first time a responsibility on those who are going to send takedown notices under the DMCA to do a fair use analysis before they do so, and make sure in their own minds that they're confident that there's not a good fair use argument for the video in question or the article in question. This isn't limited to videos being taken down. So it's like a due diligence requirement before you go ahead and send a DMCA takedown notice. It seems to me that in the way the Ninth Circuit has now amended that opinion. So not only did it put it out there, it has decided perhaps that its original opinion was too narrow and made the obligation on the person who wants to send a DMCA takedown notice too light. It seems to me its changes to its opinion have now heightened that burden further. Do you agree?
I do agree. I think the changes are significant. There were two words in the original opinion that I agree with you seem to make the opinion rather narrow in terms of what the content owner had to do in terms of a fair use assessment. In the original opinion, the court said that the fair use assessment need not be searching or intensive. So that seemed to limit the holding in a fairly meaningful, substantial way. Mm-hmm. It didn't have to be this exhaustive fair use analysis. Court wasn't exactly clear as far as what was necessary, but you knew it didn't have to be searching or intensive. Those two words and a substantial other portion of the opinion have been amended. That is no longer in the opinion that the Ninth Circuit just reissued. So the question arises now, well, as a result of it being amended and that language taken out, does it have to be? Does the fair use analysis have to be searching? Does it have to be intensive? Or is it something else? That I don't know, and I'm not sure that anyone has the answer.
Right, and then the Ninth Circuit also made another change that seems to put more burden on rights holders. It originally had talked about using an algorithmic method to, was it to make your assessment or to detect possible infringing works? The implementation of computer algorithms appears to be a valid and good faith middle ground for processing a plethora of content. So it seems to be on the screening side that the court was endorsing that as the way you flag issues for a possible takedown. And now it's removed that language as well.
Correct. So what the court initially indicated is that if you employ some sort of digitized algorithmic method in searching for content that's hosted on a service provider site, that seems to be a good, what the court said, middle ground for searching for and then ultimately looking at that information to issue a takedown notice. That language has also been removed. So it does raise the question of, well, if I am a content owner and I have a substantial amount of content that I am concerned about as being on these various service provider sites, if I'm worried about that, can I still comply with the court's fair use requirement and search for that using algorithms that go out and target the content and then ultimately issue takedown notices as a result of my findings? I think that opens a question as to whether that process is still considered fair use under the court's court's analysis.
Ron, Mike and I are both in the Ninth Circuit. You are not. Has this case had any ripples out on the East Coast? Do you feel like your clients or those who might be adverse to your clients or rights holders in general in your jurisdiction are paying attention to the fact that the Ninth Circuit wants them to do a thoroughgoing fair use analysis before sending a takedown notice?
Well, first I'll have you know I'm admitted to the Ninth Circuit.
All righty, good.
And in fact, I wrote a post on this, doing kind of a tag team with Michael because I thought he did such a good job on his first post on this topic. Mm-hmm. And the reason the Ninth Circuit matters so much is because in the Ninth Circuit, this opinion is really critical because unlike, for example, in the Batmobile case, which stands for the general proposition that what the studios generally want in the Ninth Circuit, they get. In this case, they didn't. Mm-hmm. And that's really significant. This is a very important decision. And although it doesn't directly affect any particular category of my clients, who it does affect almost everyone in America's clients because all things being equal, people who have takedown issues with YouTube who want to litigate it are almost inevitably going to find themselves in the Ninth Circuit. If they find themselves pushing back, they're going to probably find themselves under the user agreement between them and YouTube in the Ninth Circuit. This is an astonishing outcome. And I just want to address the question you and Mike were just talking about that language that was removed. I'm a little bit inclined to say that the reason that language was removed about the middle ground is that because it was unnecessary. I don't need the Ninth Circuit to tell me what algorithms I can use as an intermediate step prior to setting out the cease and desist letter. That's up to me. Mm-hmm. That's how I go about processing and making decisions as to enforcement are entirely internal. What matters is once I send the takedown notice, now when I press the trigger, that's when I'm on the hook. And the Ninth Circuit really stepped up and did the right thing here and said, you've got to take responsibility. It's not enough to say, listen, we've got a gigantic problem and we're going to shift the burden of whether we're right or wrong. Because our problem is so great, we're going to do our best to be in the ballpark. And if we're wrong, it'll be the problem of the guy whose video we take down. And we'll make it, we'll let them worry about just how precise our results are. The Ninth Circuit said that that's not good enough. And that's the appropriate standard. The DMCA gives the owner of copyright protected properties a tremendous tool. You don't have to go to court to enforce your rights. Once you come to a bona fide, good faith conclusion that your rights are being violated, you can go to a YouTube, you can go to a third party publisher and say, under the DMCA, I'm empowered to instruct you to have this taken down under pain of A, B, C, and D. That's a gigantic self-help tool. It has to be wielded in the best of faith. And you can't empower a paralegal or a functionary within your organization under very vague guidelines. And under the facts of this case, the guidelines were pretty damn vague. There's music playing in the background. That's not going to cut it. If you've got a question about whether music playing in the background rises to the level of this has provided background music to a video and is there enough of it in it, ask a lawyer. Take the time to ask a lawyer. There are lots of them on the set. There are lots of them in California. You can find someone to ask. It doesn't have to be done today. It can be done tomorrow. They didn't bother to do it here. They made it the problem of the person who posted the video, who amazingly found the time to push this all the way through and got the right answer.
Yep, I agree with you. And I think that this is a big deal and that we will see lawsuits that flow from this standard when companies ignore this decision to their peril. Mike, any final thoughts?
Yes. So Ron mentioned the fact that it may be necessary to consult with legal counsel, and I agree with that. That is a possible outcome here. That you may have to actually consult with a lawyer. But then what? Fair use issues are notoriously fact intensive, and it's very nuanced, and it differs from circuit to circuit. And so are we going to be faced with a situation here where I think under the initial opinion where the court said it doesn't have to be searching or intensive, I think that gave people some comfort as to the level of fair use analysis that was necessary. But now, do I need to consult with the lawyer? And if so, am I going to be forced to actually disclose what the conversation was with the lawyer to establish that I had a good faith belief that this was fair use? I don't know. Maybe that's an extreme circumstance, but I think that is a logical result that comes from the court's opinion.
Yeah, that is a toughie, because that would be the way to establish it. And of course, we have confidentiality rules in place that people aren't supposed to have to discuss their conversations with their counsel and their analyses and their decision-making process. But this seems like it almost requires an exception to that. Do you agree?
Potentially, yes. I mean, depending on the use, and depending on a whole host of circumstances, it could be a thorny issue. It could be complicated. It could be difficult. And if you're just a content owner, be it a big corporation or maybe just someone that self-publishes content on the side, these can be difficult. You may need to consult with the lawyer, and who knows what happens there if ultimately your takedown notice is challenged. So I think it's a very significant decision. I think there's still a lot of answers. I thought there was a lot of questions under the original opinion. I think there's even more questions as a result of the amended opinion.
Yep. All right. Well, we're going to get in a moment to our second most pun-worthy case of the day. Hulk Hogan did some serious body slamming in the headlines, and the Supreme Court has done a lot of punting. We'll tell you what we mean by that in just a moment. Before we do that, I hope you're getting hungry, because now it seems like a really good time to talk about Blue Apron. You need to know how to cook. And when you're using Blue Apron in your kitchen, not only will you feel like you know your way around the kitchen, but cooking at home means eating healthier and saving money instead of ordering expensive takeout again. Where do you start? And where do you start if you're not the person who's sort of the primary chef in your house? I love Blue Apron for folks who want to ease that person's burden a bit. And it really makes it easy to do that. If you're not the person who's constantly doing the shopping and the cooking, you may not be very comfortable with that role, but Blue Apron has you covered, because for just $10 a meal or even less, Blue Apron delivers all the fresh ingredients you need to create home-cooked meals. Just follow the easy step-by-step instructions. Each meal can be prepared in 40 minutes or less. No overwhelming trips to the grocery store, no more sad takeout. No matter what your dietary preferences are, Blue Apron makes it a breeze to discover and prepare dishes like fried chicken with baked sweet potato and collard greens, or orecchiette pasta and roasted chickpeas with kale and smoked paprika right in your own kitchen. Cook with ingredients that you've never used before, such as watermelon radishes, farro, and purple potatoes. Recipes are very healthy. They're between 500 and 700 calories per portion. They're delicious and good for you. And right now you can get your first 2 meals free just by going to blueapron.com/twit. Check out this week's menu and get your first 2 meals free by going to blueapron.com/twit. Thank you so much, Blue Apron, for your support of This Week in Law. All right. So what the Supreme Court has famously punted on here, as far as all the pundits are concerned, is an important case that was decided again in the Ninth Circuit involving publicity rights of NFL players as infringed, according to the lower court, by EA, Electronic Arts, in making a video game that relied on NFL players' likenesses in the game. The Supreme Court, without any comment, decide to grant certiorari, or we could get into the discussion. I love having that discussion on this show, how we pronounce whether the Supreme Court grants cert or not. Most of it's just say cert to skirt the issue. It did not grant cert. And that case will stand as decided in the NFL players' favor. Ron, what are your thoughts on the Supreme Court declining to get involved here?
Well, what are my thoughts on the Supreme Court's not getting involved? No surprise at all. They are not all that crazy about IP cases. They're not all that crazy about soft IP cases, and this is a pretty soft one. Rights of publicity are themselves creatures of state law, and the Supreme Court is much more interested in federal law than in state law. And it's, to the extent, I mean, I take that back to the extent that there are trademark issues here, unfair competition issues, 43A. Those are federal law issues also, but they're, generally speaking, this is an area of the law that I think that the Supreme Court would probably like to see develop without its assistance. It frankly probably considers the whole thing beneath it. I don't know quite any other way to put it. Right. On the other hand, it does strike me as as a very important area of law to be left to one circuit to essentially develop. It's not surprising that so much of it would come out of the Ninth, but you do have the influence in the Ninth Circuit of California state law, which is unusually protective of rights of publicity, whereas all the way back on my side of the continent, you have a much weaker regime for rights of publicity. They're not inheritable. They end at death. Athletes in particular, in general, have the most, athletes and other celebrities, of course, have much more protectable rights of publicity than people like you and I who, aren't really brands.
Right.
But, on this particular question of, whether a game maker has to get separate rights from the league, and as opposed to rights from the players themselves, the outcome doesn't strike me as a particularly counterintuitive one.
Yeah, it seems like a very nuanced case to me because, when we talk about rights of publicity, the phrase that's usually used and the phrase that's usually used in the laws about such things are a misappropriation of someone's name and likeness. And here, names weren't in play. What we had were sort of interpretations of players that the players said, that's clearly me, based on the age, weight, other characteristics, body build, information that identifies that character as me. But no one in EA Madden Sports was supposed to be the actual football player. That's right, isn't it, Mike?
You're right.
Yeah.
Right. The names weren't used. It was more the indicia of these former NFL football players that would allow a gamer to connect the dots.
Right. So
it's the Bette Midler kind of.
The Bette Midler kind of.
Yeah.
Well, right. Yeah. Go, please, Mike. It's your turn.
Well, so this, I think what Ron's referring to is a former right of publicity case involving Bette Midler, where somebody, I think it was Ford, if I recall correctly, had commercialized a sound-alike for a car commercial that sounded like Bette Midler. So it didn't use her voice, it didn't use her name, but it used somebody that sounded like her, and that was the intent. They wanted to have somebody that sounded like Bette Midler to commercialize and apparently take advantage of her popularity. So it's akin to that.
Right. And it also invokes free speech concerns because that's what EA hung its hat on and was hoping to make some headway on with the Supreme Court. That as an entity, and we're back to who has free speech rights or not. There was some back and forth in the courts below here about how protected video games would be from a free speech standpoint, whether they're an expressive medium like a film. What happened in the Ninth Circuit is they were not found to have those same kinds of strong protections. And so now that is going to stand unless undone by another court and brought up to the Supreme Court in that case. As you point out in your post on this, Mike, it would have been nice, perhaps, to have the Supreme Court take a right of publicity case because, as you write, the last time the court considered a case involving publicity rights was back when the typewriter was still very much in vogue technology, 1977 or so. So are you surprised to see it not get taken up?
Frankly, I am. And here's why. As a matter of fact, I was so convinced that the court was going to take it. I had a draft blog post that said the court has taken it, and it's notable for the following reasons. Of course, I had to modify that when the court didn't take it. But here's why I think this is much bigger than the Davis case in the Ninth Circuit. As 31 law professors indicated to the court, there are 5, and actually since that brief was written by those law professors, my take is there's 6 different tests that are wending their way through the various federal circuits as to how the First Amendment interacts with these state right of publicity claims. And it's not just that there's 6 different tests that are kind of mostly similar. They're fairly divergent tests that are used. And let me give you an example. So in the Ninth Circuit, the Davis case that we're talking about, the Ninth Circuit uses what's called the transformative use test, meaning you've got to transform this individual's persona in some meaningful way. And the court found that there wasn't any transformation here as a result of these players being used. Even though their names weren't being used, it was their likenesses. It was the color of their skin and their body build and their jersey number. Court said that's not protected. The right of publicity case goes on. So look at the Eighth Circuit. A number of years ago, the Eighth Circuit decided one of these sports fantasy cases. These online sports fantasy draft picks and what have you. The Eighth Circuit, I think is in an analogous case that you could say is factually analogous, came out the other way and said, no, the right of publicity claims are barred. You can use a player's name and statistics in order to create this online fantasy betting pool or whatever was involved in that particular case. So to me, I think that's a nice contrast. And there's other circuits. The Second Circuit has a different test, and the Third Circuit has a different test. So multiple tests in a federal circuit it's always a good recipe for the court to take it, particularly here where you've got these right of publicity claims that are seemingly more and more prevalent. And I think it's an important issue. I mean, you go back to my blog post when I talked about the case in 1977 that the court took. I mean, my goodness, that involved a fellow by the name of Zucchini, the human cannonball that shot himself out of a cannon. And the court found that case was worthy to accept back in 1977. For my money, the EA v. Davis sports case is far more significant in terms of what it could have represented for the court to clarify. So I've learned my lesson that I'm not going to write a blog post, a draft, until I know for sure what the court's done. Right.
And I'm sure EA has not written a check to the NFL or its players, or it may have written it now, but it didn't write one until it had this word from the Supreme Court. Do you know where things stand at the trial court level now? EA has no more recourse. So do you know what damages will be awarded against it?
Is that for me, Denise?
Yeah. I'm just wondering if you know.
Yeah, I'm not sure if there already was I don't think there was a trial. I think this was an appeal. So I think it's remanded, and maybe now there will be a trial.
Now there will be a trial,
assuming that the parties don't settle.
Right. I just pulled up the Ninth Circuit decision, and what the Ninth said it did was affirm the lower court's motion to strike, I assume, the complaint. So that would imply that there wasn't a trial, and yes, the parties would either settle or have one at this point. So we'll continue to take a look at that and see if EA thinks it has any other arguments to make, aside from the ones that have now been ruled out under First Amendment grounds.
Well, Denise,
yes, please.
I think that you'll find if you know, whether it's settlement or if it does go to trial, and I think it's unlikely to go to trial, because the settlement parameters are going to be pretty clear. What would the license fees be for these players if they had licensed their identities under the normal course, for a video game? And these are the license rates are fairly well established in these kind of contexts. And then there's probably going to be an attorney's fees component. It's going to be a pretty large check. So there's your answer.
Right. I think we'll make me and my avatar our second MCLE passphrase for this episode of This Week in Law. And we'll move on to discuss an interesting development on the patent front. I bring this up to close out the show because it's just kind of a feel-good story, and it's a bit reminiscent of what we discussed earlier, where the Justice Department has decided to back off and see if they can get into the phone without Apple's help. Here, there was a patent case filed against a pastor who was making foam arrows used in LARPing, and was selling those arrows to camps, churches, and resorts, the kind of people who might foster LARPing among their constituents. And the pastor was sued by a company called Global Archery, that claimed it had a patent that covered the foam arrows that the pastor was suing. There was a story about this at Ars Technica, and in writing it up there, Li Cheng, who's patent counsel for Newegg and has been on our show before and is sort of a poster child patent warrior, anti-troll patent warrior, saw the story and commented on it, that he was happy to help the pastor, whose name is Jordan Gwither. So the two got together. Li Cheng told Jordan that he would help give some financial support to their fighting off the patent infringement claims, and in fact would give the more than $10,000 that Newegg has made from selling anti-patent troll T-shirts, of which they have 22. If you're interested in acquiring one, particularly now that you know that they're doing great good with the proceeds from the sale of these T-shirts. So Newegg got on board, gave some money that helped Mr. Gwither fight off the case, and the company that sued has actually decided to back down at this point. They dropped their patent claims, reportedly, according to them, after seeing more prior art. They take umbrage at being characterized as a patent troll. They apparently this is the first time they've tried to assert their foam arrow patents, but kind of a great confluence of a lawsuit in need of help and a patent warrior in need of someone to help coming together via Ars Technica. I kind of like how that all came together and then went away. Mike, any thoughts about this?
Yeah, it's a great way to end your show. It's a great story, and brilliant marketing by Newegg. So well done.
Yes, their patent shirts are definitely, or patent troll hunting shirts are definitely worth checking out. There's some very stylish ones over there, and we see how their proceeds are being used for good. Any thoughts, Ron?
Well, it's just another reminder of the scary aspect of the unrepresented private civil defendant. Especially in a statutory fees world. I've done some pro bono work in this area, and sometimes the most fundamentally flawed claims are able to result in people really getting railroaded because they simply can't afford even the initial consultation with a competent lawyer who is competent to give advice, a lawyer who's competent to give advice in the subject matter. And the Newegg here thankfully stepped up and stood between the recipient of a meritless cease and desist demand and made a problem go away just by saying, hey, what's going on? And that's sometimes all you need to do is just pick up the phone or write back and say, what do you think's going on? What's going on here? And that's a big problem with our situation now. Defendants who just don't have anyone to speak for them. It's bad enough in the criminal system, which is an absolute travesty. But you can ruin people's lives, careers, professions. Their businesses very, very readily. And there doesn't seem to be, not everyone gets a Newegg or a friendly neighborhood lawyer to step up and help them out. So this is a feel-good story, I'll say that much.
Yeah, definitely. Nice to have something positive to talk about to wrap up the show. We're also going to wrap up our show with a tip and resource that we hope will be useful or at least entertaining for you. Before we give you those, though, we'd like to thank our final sponsor for this episode of This Week in Law, which is PillPack, a full-service online pharmacy that combines modern technology, convenient packaging, and personalized service to make your life easier. We've gotten used to dealing with the drudgery of our traditional pharmacy. You wait around at the pharmacy counter to be told your prescription isn't ready, and then you have to hassle with sorting your medication. And on top of it, constantly be in contact with your doctor or health insurance company. It can be a real pain. Well, there's a new technology company disrupting the pharmacy space. It's called PillPack. PillPack is an online pharmacy that will make you wonder why you ever settled for a traditional pharmacy. PillPack works just like a normal pharmacy, except they deliver your prescriptions right to your door so you never wait in line. They use advanced technology to sort your medications and vitamins by the dose so you can avoid the confusion of sorting your own pills. And pill packs go through an image recognition system that is built to ensure the right pill is in the right pack. Their system can even detect dispensing accuracy by size and shape. And they handle any issues with your doctor or insurance so you don't have to. The best part, the service is free. You just pay your regular copays like any other pharmacy. It's been recognized by Time Magazine as a top 25 invention, and Jill Duffy gave it a great review in PC Magazine. I don't know about you folks, but the only time I can ever get to the pharmacy is when it is at its most crowded. So that line is something that is a part of your life. If you're like me and you can only get there at the end of the day or on a weekend when the line can be all the way up the aisle behind the pharmacy. And the whole notion of, gee, do I have enough refills, et cetera, to make this actually a worthwhile trip is always up in the air. So PillPack solves all of those problems. It enables you to take what you're supposed to be taking at the right time, and it sends them to you in a wonderfully organized presentation where all of your medications and supplements are together. They're presented to you so that you have the right thing in hand to take at the right time. And it really makes your life easier. So you should sign up now. You're going to visit pillpack.com/twit to do that. It takes only 5 minutes to get started, and they take care of everything for you. When you use our link and transfer your prescriptions to PillPack, you'll get a credit for $20 worth of vitamins and OTCs. That's pillpack.com/twit. Thank you so much, PillPack, for your support of This Week in Law. All right, our tip of the week segues very nicely from the right of publicity discussion we were just having about the NFL versus EA. And this is something that I think Eric Goldman posted and that I spotted. Only his brain would go toward seeing right of publicity issues in all of this, or, you know, like other lawyers and legal analysts in the world, that's right where we want to go with this sort of thing. And in every election cycle, you see, this really impacts the speech considerations we were talking about earlier. You see candidates get sent up and lampooned, and products and parodies made of them. And from time to time, you do see them sue for under these right of publicity laws we've been discussing, for an unauthorized use of their name and likeness for commercial purposes. Well, in this particular election cycle, there are more products than usual that seem to be oriented around, or definitely are oriented around, Donald Trump. So we thought we'd highlight some of those for you. There is the Donald Trump piñata that is quite popular south of the border. Gucci actually has some slippers that come in a color of goat hair that Gucci describes as new natural. I'll let you decide whether you think they're referencing Trump or not, just with that language or the look of the things. There are Donald Trump sanitary pads for sale on Etsy, making reference to Trump's remark about Fox News anchor Megyn Kelly. There are hats that play on Trump's Make America Great Again slogan by Make Donald Trump Again. That would be a Last Week Tonight reference, if I'm not mistaken. Many other products, including condoms and cat scratch devices, all invoking the name of Donald Trump, his name and likeness for commercial use, for sure. So he has said he wants to open up the defamation and libel law situation. We'll see if he decides to take advantage of any of the states' right of publicity laws to put a stop to some of these products. Ron, do you think he will?
The executive in the federal system in the United States constitutional system is just about the least influential person in government when it comes to defamation law. Defamation law is entirely a creature of state law. The only effect that the President of the United States has on defamation law is the appointment of judges. And even that's fairly attenuated. On the laundry list of things that presidents typically vet justices and judges for when selecting people to fill vacancies, their view on defamation law is not typically at the very top of things. Now, if he wants to elevate that to the top, it will still be a very attenuated process before he has any kind of effect nationwide on the law, especially considering that the relatively, but I guess if he means to loosen them up, then what we'll call a very tight, a very strange way of referring to it, because it's probably more appropriate to put it the other way around. But the extremely hard to overcome standard for defamation under existing Supreme Court standards, precedent is not going to be overcome by any lower court judge in the federal system. And he's not going to get to reshuffle the Supreme Court anytime soon. I suppose if he were able to pass if he were able to get the sort of support that he probably imagines he's capable of getting and spearhead a constitutional amendment that would change the standards for libel law, that would be the only thing I could imagine that would be possible. But I don't believe that's possible.
Right. Mike, as to these Trump mocking products that might get someone sued, most political candidates or those in office tend to just let this stuff go. Do you think Trump might be the exception?
I suppose if there's an exception, the Donald would be it.
Yeah.
I guess we'll have to wait and see.
I guess we will. But we wanted to let you know both that these products are out there for your humorous consideration, and also that, he could be the exception and the one that decides to come after you if you're like Gucci making Trump slippers. I wouldn't do that. Maybe Gucci will come after you. Our resource of the week is a set of legal guidelines. This is for our developers and coders out there. If you are working on products, apps, other web applications that make use of location data on the web, there's a wonderful legal guideline list over at Smashing Magazine that walks you through considerations that you should be thinking about if you are using location data at all. This is just the tip of the iceberg. It's a pretty lengthy article, so I encourage you to go through it if this impacts you at all. At least it gets you thinking along these lines. When I read through it, I didn't see mention of COPPA, which also should be on your radar if you're using location data about kids. That would be the Child Online Privacy Protection Act. In a world where I think it's 40% or less of apps that collect data actually have a privacy policy. That was something I read during the last week. So you can look up that stat and fact check me on it. But it's a world where still people's compliance with the laws around their use of data is falling short of where it needs to be. So these legal guidelines are a great start if you're using location data on the web, and I encourage you to check them out. All right, this has been a really fun, interesting, wide-ranging show. We're so thrilled that Cash Hill was able to join us for the top part of the show. Mike Keyes, it's wonderful to see you again. Thank you for coming back so soon.
Denise, thanks for having me. And Ron, it was great to be with you, and I wanted to make sure to wish you all the best of success in your continuing fight for the slants.
Thank you. Thank you very much. It's a fight for the First Amendment. Slants happen to be our client, and they come first. But I think everyone's interests are going to be affected. Even if they think otherwise at the moment, everyone's interests will be affected, hopefully, with the continuation of this effort. Thanks.
Right. And we talked about the slants a bit when Mike was recently on the show. Can you remind us, Ron, where things stand procedurally with that dispute?
Well, the Federal Circuit issued its opinion on December 22nd, reversing the TTAB's original affirmance of the PTO's refusal to register the slants trademark on the ground that it was disparaging. So they reversed the TTAB's, the PTO's, ultimately the PTO's decision, and remanded it back to the TTAB, which is the PTO, for further proceedings. And we kind of began to wonder when those further proceedings were going to proceed. Something called a mandate came down about 3 weeks ago. A mandate is, as you guys know, something that an appellate court does after it makes a final decision and says, okay, we really meant it. And that happens in all appellate decisions. It's the other shoe dropping in an appellate process, and it tells the agency or court from whose decision the appeal took place that we've, our opinion is final, and now you are directed to do what we said you should do. Nothing happened. So the slants asked the PTO what its intentions were, and the PTO's response was, well, we are waiting for the Supreme Court to issue its opinion eventually, and we thought that was an odd thing because usually when you appeal and win, that usually counts for something. So we filed a motion for a writ of mandamus last week with the Federal Circuit saying, Dear Federal Circuit, we thought we won. And the PTO doesn't seem to think that matters. Yesterday, the night before last, we got the papers from the PTO, which were a response to our request for a writ. 9 government lawyers were involved in the preparation of that response, and I'm not going to comment on the response until we file our reply next week, which will be the comment. And then we'll leave the Federal Circuit to issue the only comment that matters.
Great. We will continue following along with the case, and we wish you good luck in representing the slants.
Thank you.
Hey, Mike,
I've already started my blog. I wanted to say I've already started my blog post.
There you go.
I'm looking forward to. I'm looking forward to it. I'll leave it at that.
Right. Mike, too, I wanted to follow up on your brother-in-law, Joe Lathe, who we dedicated episode 338 to when you appeared with us last. I understand that in the intervening weeks we have lost Joe, and I just wanted to convey my condolences and hope that your family is doing okay.
Well, very much appreciate that, Denise. It was a wonderful tribute. He was very touched. Several family members tuned in from all across the land to see it, and they loved it. So very much appreciative, and we're doing fine. Thanks very much.
Good. And he sent me an email after the show, too. That was so kind of him. It was great to get to have a brief interaction with such a wonderful person.
I'm glad to hear that. Thank you.
All right, folks, that is it for this episode of This Week in Law. We will be back next week. If you have joined us at 11 o'clock Pacific time, 1900 UTC, that means you've joined us live. Thanks so much for doing that. We love it when you can. Don't worry about it if you can't, though. You can always head on over to twit.tv/twill, where our entire archive of shows exists for your listening pleasure at your leisure. And also there are wonderful suggestions there as to how you might enjoy the show, whether you like to watch it on a computer or a TV, listen to it as you work out or run errands. However you join us, we're thrilled that you do. We love that you are able to participate in the show. We hope that you'll be an interactive part of the show, whether that involves jumping into our chat room as we record or getting in touch with me and Emery, who couldn't be here with us this week. Between the shows, you can reach me. I'm Denise at twit.tv. You can find me on Twitter, get in touch that way. You can find our Facebook page or Google Plus page for the show. Those are all great ways to let us know what you've thought about what we've discussed, your take on the issues, what you think should be on our radar that's not, and people who you think would be wonderful additions to our roster of illustrious panelists. Please, please reach out and let us know all those things. It's very, very helpful, and we love hearing from you. Thanks so much for joining us. We'll see you next week on This Week in Law.